in a quorum call?
We are not.
Thank you, Madam President. Madam President, yesterday was an interesting day for me personally, but it was an interesting day, more importantly, in the history of the United States when it comes to the Equal Rights Amendment. The Equal Rights Amendment was first introduced in 1923, 100 years ago, 100 years ago, and proposed by a leader named Dr. Alice Paul. At the time, she had just won an important victory. She and her fellow suffragists had just led successfully the campaign to ratify the 19th Amendment, to give women the right to vote in the United States, 100 years ago. Despite this monumental achievement, Dr. Paul recognized that just the right to vote was not enough for gender equality, but it was the right starting point. So she devoted the remaining years of her life to enshrining gender equality in every facet of American life, and particularly into the Constitution with the Equal Rights Amendment. Sadly, Dr. Paul and her fellow suffragists passed away long before they could see the ERA become the law of the land. But their legacy lives on today in a new generation of activists, lawmakers, and trailblazers who are propelling the movement for equality forward. Now, the personal side of this relates to the fact that when I graduated from law school in 1969, I went to work for the Lieutenant Governor of Illinois, Paul Simon, who later served here in the Senate. And one of my first assignments in the Illinois State Senate was to work for the passage of the Equal Rights Amendment in the state of Illinois. The road to ratification has been long and winding. I continue to be amazed by the proposal. 50 years ago, it really came down to some very basic arguments. And the leading argument against the Equal Rights Amendment was that men and women would have to share public restrooms. When I say that, you think, wait a minute. You want to enshrine in the Constitution the constitutional rights of more than half of the people living in America, and the article came down to a debate over the future of public restrooms? I'd have to tell you that had more to do with it than almost anything else. I heard that argument over and over and over again. The ERA is a rallying cry for Americans young and old for good reason. As the 28th Amendment to the Constitution, it would ensure that our nation lives up to the promise of real equality. And frankly, it's a principle that should be enshrined in the Constitution. Now, 38 states have ratified the Equal Rights Amendment in the past half century. The most recent, Virginia, in 2020. 38 is the exact number needed to certify an amendment to the Constitution. The only thing standing in the way of an Equal Rights Amendment is an arbitrary deadline that Congress included in the preamble. Let me underline those three words, in the preamble of this amendment as it passed in 1972, clarifying that this was not controlling, but simply in the preamble is what the current controversy is about. During yesterday's hearing on the ERA, we heard from several witnesses, my own home state senator, home state lieutenant governor, Juliana Stratton, a young woman whose name is Thursday Williams, first-generation American, board member of the ERA Coalition, senior at Trinity College in Connecticut. She spoke on behalf of a lot of young people. She's a college senior. Her compelling testimony was a testament to the value of her voice in the conversation. I'm glad she was there. After graduating college, Ms. Williams plans to become an attorney. She said, quote, "I fell in love with the United States Constitution in high school." You don't hear that very often, do you? She said, quote, "What I love the most about the Constitution is how brilliantly it was designed to adapt to the changing needs of its people." She argued that today the American people deserve a Constitution that guarantees equality regardless of sex, a Constitution that we can use as a tool to fight discrimination. She concluded her testimony by asking the members of the committee, if we continue to hold back more than half of the people in America from accessing equal opportunity, what does that say about us as a country? How can we be the beacon of freedom and democracy we claim to be if we don't declare that sex discrimination contradicts the American dream? This young college student's pretty smart as far as I'm concerned. She knew exactly the right question to ask. And generations of Americans have been waiting for us in Congress to protect their fundamental rights. Congress approved the ERA 50 years ago, but in doing so, we imposed that arbitrary time limit for ratification. That's why our hearing yesterday was so important. The members of the committee were not merely discussing the importance of the ERA, we were urging our colleagues to join us in passing it. This joint resolution already has bipartisan support in both chambers, and I want to salute Senator Murkowski of Alaska for joining us in co-sponsoring with Senator Ben Cardin this effort. We can't wait any longer. I listened to the arguments about opposing the Equal Rights Amendment in this year, 2023. 50 years ago, the argument was, we can't see how we're going to resolve public restrooms. Now the argument was raised by one of the witnesses called by the Republicans was, we're worried about the impact that an Equal Rights Amendment would have on the future of field hockey. Field hockey. The woman who testified, representing one of the koch industry entities that have been created to do politicking, said she couldn't explain to her daughter or guarantee to her that there wouldn't be some clash as to whether men could play on her field hockey team. I would say to her with all due respect, and I've been a parent myself, still am, that it's time to sit down and talk to your daughter about the basics. And the basics are a constitutional guarantee of her rights for the rest of her natural life, not the next field hockey game. There's more at stake here. And it probably relates less to her because of who she is and her family than it does to all the other women whose lives would be improved by the passage of the Equal Rights Amendment. But that's where we stand today. There's no room for uncertainty when it comes to protecting equal rights under the law. That's a lesson that was driven home last year when the Supreme Court overturned Roe versus Wade. For the first time in history, for the first time in the history of the United States of America, the Supreme Court ripped away a constitutional right from the American people. That's never, never happened before. And one of the Supreme Court justices, by name Clarence Thomas, made it clear that this was just the beginning. He was going to call into question a lot of fundamental constitutional rights, like the right to privacy, the right to reproductive freedom, the right to family planning. So now, members of the Senate have to make a decision. In our time, what kind of America do we want for our granddaughters and daughters? A country in which their fundamental rights are safe and secure, or one in which the Constitution still 100 years after we started, fails to recognize a fundamental equality on the basis of sex? I think the hearing was very clear, and I think the issue is very clear. I know what I want to be able to explain to my little granddaughter. She's only 3.5 now, but I hope to live long enough someday to sit down with her and have a serious conversation about this. And I want to tell her that during the course of my life, her constitutional rights in America were at issue, and that we did the right thing for her and for her daughter and her daughter's daughter and everyone born in America in guaranteeing basic equality. Madam President, I ask that this next statement be placed in a separate part of the record.
Without objection.
I want to tell you about a young law student whose name is Layla Murphy. She was 3 years old when her father, Brian, was killed. Her older sister, Jessica, was only 5. It's a day Layla was too young to remember, let alone comprehend. But for the Americans who are old enough, it's a day we'll never forget. 9/11, 2001. Layla grew up in the shadow of the 9/11 attacks. She recently wrote me a powerful letter about the failure of this country to deliver justice. I quote her, "My father, Brian Murphy, worked on the 105th floor of the World Trade Center. He was killed when the first plane struck the North Tower. 22 years and 4 presidents later, there's been no accountability for his death, nor the deaths of nearly 3,000 other Americans that day. Layla and 3,000 other families like hers have been waiting for justice for 9/11 for almost 20 years, maybe longer. In those 2 decades, Layla has grown from a toddler to a law student. But the military commission trial against the 5 9/11 co-defendants in Guantanamo has never even started. 22 years later. Let me repeat that. More than 2 decades after the attacks, the 9/11 trial has never even started. In her words, she said, the parties are no closer to a trial date than when the hearings began in 2012, more than a decade ago. In the meantime, many family members have died, others have given up hope. They don't know that this case will ever end in their lifetime. Layla has traveled to Guantanamo to watch the military commission proceedings and came away frustrated and, in her words, ashamed. Frustrated at the slow pace and makeshift nature of the proceedings, ashamed to learn how the defendants were actually tortured by her own government. Layla recognizes that because of this history, real justice is now unattainable. By setting up ad hoc military commissions rather than trusting our courts, by torturing detainees rather than securing evidence lawfully, we have made true justice for families like Layla's virtually legally impossible. If pretrial proceedings are still going on 20 years after the event, how many years do you think the actual trial would take? How many years of appeals would then follow? What are the chances that prosecutors can even convict men who were tortured at our hands for years? And if they did, what are the chances that those convictions would be upheld? How many family members will still be alive to see final judgments of guilt, if they ever come? The reality is that securing guilty pleas in the 9/11 case is at this point the only way to deliver a modicum of justice to the victims and their families. The Biden administration should step up to the plate, deliver the justice that 3 previous administrations have failed to provide. In Layla's words, and I quote, the military commissions have failed to provide justice for 9/11 families. Plea deals are a way out, the only way out maybe, but the thing standing in the way is political will. She says, Layla says, it's time for that to change. She's not alone in recognizing that guilty pleas are realistically the only hope for justice. On the morning of 9/11, former Bush administration Solicitor General Ted Olson went to his office at the Justice Department while his wife Barbara headed to Dulles Airport for a flight to Los Angeles. Barbara planned to leave the day before, but she delayed her departure by a day so she could wake up with Mr. Olson, her husband, on his birthday. After the 2 planes hit the World Trade Center towers, Mr. Olson's thought turned to his wife's safety. At first, he was relieved when an assistant told him she was on the phone, but she was calling from the back of the airplane to tell him that her plane had been hijacked. She wanted to know, she asked what she could tell the captain, and then silence. At 9:37 a.m., American Airlines Flight 77 crashed into the Pentagon, killing all 64 people aboard and 125 people in the Pentagon. Barbara was one of those victims. Like Layla, Ted Olson is still awaiting justice. But today he believes that true justice seems unattainable. By coincidence, I ran into him last night at a reception here on Capitol Hill. And I went up and introduced myself to him. And I said I was going to talk about his statement and his wife on the floor. And he thanked me for it. He said, it's time for the American people to hear this straight from those of us who were directly impacted by 9/11. In a powerful column earlier this month, Mr. Olson wrote, and I quote him, I now understand that commissions were doomed from the start. And he said, we tried to pursue justice expeditiously in a new, untested legal system. It didn't work. The established legal system of the United States would have been capable of rendering a verdict in those difficult cases, but we didn't trust America's tried and true courts. He concluded, and I quote, nothing will bring back the thousands of lives so cruelly taken on that September day, but we must face reality and bring this process to an end. The American legal system must move on by closing the book on military commissions and securing guilty pleas. In the fearful days after 9/11, our nation's leaders made a fateful decision to forsake our most trusted institutions and betray our cherished values. The decision to open Guantanamo in a rush for vengeance and swift justice instead robbed the victims of 9/11 and their loved ones one of their true rights to true justice. It's time to salvage what justice we can by bringing this commission cases to an end. We must also bring an end to the shameful, indefinite detention of detainees who have never been charged with a crime. More than 2 decades after the incident of 9/11, these detainees have never been charged with any crime. 18 of the 32 remaining detainees have never been charged with any crime and have been unanimously cleared for release, 18, by our national security and military leadership. Yet they continue to be detained indefinitely, day after day, year after year, for more than 2 decades. The administration must redouble its effort to transfer the men who've been cleared for release or serve their sentences. The recent transfer of 3 longtime detainees were steps forward, but the administration needs to pick up the pace. Men who have served their time or been cleared for release should not be sitting in Guantanamo. Ending these abuses is a moral and national security imperative. Guantanamo Bay continues to serve the interest of America's worst enemies. Terrorist groups point to the history of torture and indefinite detention in their propaganda and recruitment videos. Autocrats point to Guantanamo to justify their own human rights abuses. Adding insult to injury, this moral stain on our nation and national security liability continues to be funded by American taxpayers. The cost of Guantanamo is astronomical. We spend more than $540 million each year to keep Guantanamo open for just 32 detainees. Let me repeat that. $540 million a year in taxpayers' money to keep Guantanamo open for 32 detainees. That's nearly $17 million a year for each detainee. It's an outrage. And 18 of those men have been cleared for release for a long period. We must not forget that Guantanamo was set up to be outside the reach of the law, outside the reach of the Constitution, outside the reach of the concept of habeas corpus, outside the reach of due process, and outside the reach of Geneva Conventions. That's why it was chosen. We must not forget that detainees were held incommunicado and actually tortured at Guantanamo. We must not forget that more than half the men still there continue to be detained indefinitely without any charge or any trial. In America, we must stand for something better than that. Guantanamo Bay, sadly, is a historic stain on America's long pursuit of the cause of justice. We have a responsibility to release detainees who've never been charged with a crime and who've served their time, period. And we have a responsibility to deliver what little justice we still can, to the victims of 9/11 and their families. So let's do what must be done. Let's finally salvage a small measure of justice and dignity for Layla, for Ted Olson, and for everyone else who lost a loved one on that terrible day. Mr. President, I yield the floor.